সম্প্রচার করা হচ্ছে আইন বিষয়ক অনুষ্ঠান ল অ্যান্ড অর্ডার, পরিচালনা নাহিদ রহমান ও লবি রহমান।
Human and humanity. Crime and criminal. Judgment and justice. Law and order.
প্রিয় দর্শক, আপনাদের সকলকে সাদর আমন্ত্রণ জানাচ্ছি এটিএন বাংলা নিয়মিত আয়োজন আইন বিষয়ক আলোচনা অনুষ্ঠান ল অ্যান্ড অর্ডারে। সাথে আছি আমি অ্যাডভোকেট মাশরুফা হোসেন। আমাদের আজকের আলোচনার বিষয় যুক্তরাজ্যের আইনি ব্যবস্থা ও ফৌজদারি মামলার কার্যক্রম। এই বিষয় নিয়ে আলোচনা করবার জন্য আমাদের স্টুডিওতে আজকে উপস্থিত রয়েছেন যুক্তরাজ্যের একজন আইনজীবী ব্যারিস্টার ক্যাথরিন ডান এবং ব্যারিস্টার সাজিদ এমডি তানজিদ কবির, অ্যাডভোকেট, সুপ্রিম কোর্ট অফ বাংলাদেশ। প্রিয় দর্শক, আমাদের আজকের বিষয় নিয়ে যদি আপনাদের কোনো প্রশ্ন থেকে থাকে তবে টেলিভিশন স্ক্রিনে দেখানো টেলিফোন নম্বরগুলোর মাধ্যমে আমাদের কল করতে পারেন। তবে যথাসময়ের মতো অনুরোধ করব বিষয় সংক্রান্ত প্রশ্নই আপনারা করে থাকবেন এবং প্রশ্ন করবার সময় আপনাদের টেলিভিশনের ভলিউমটি কমিয়ে রাখবেন। It's indeed a pleasure to have both of you here today.
Thank you.
My first question to you would be, since you're a practicing barrister with a wealth of experience, can you kindly state it for our viewers and give a brief overview of the criminal justice process in the UK?
Of course I can. It's predominantly the police that investigate criminal offences in the United Kingdom, but it could also be some other government agencies, like Customs and Excise, for example. Once the police have investigated the case, it is usual for them to then send the file to the Crown Prosecution Service. That is a government organisation that prosecutes offences in the UK. The Crown Prosecution Service, what they then do is look at the file, and they will then decide whether you are going to prosecute this person, in other words, take them before the court, or whether there isn't enough evidence. Now, they have quite a strict test that they have to follow, and the test is there a realistic prospect of conviction? I think another way of describing it would be, is there enough evidence to go before the court?
Right.
But there's a second stage which is quite important, and the second part of the test is it in the public interest? And you have to pass both tests before the Crown or the Crown Prosecution Service will decide to prosecute. And then it's quite simple. All cases will go to the Magistrates' Court. I think you have a similar sort of court in this country, but I'm not too sure, forgive me, exactly what it's called. But in the Magistrates' Court, all the cases are divided. The most serious cases, for example, murder and rape, they automatically get sent to what we call the Crown Court.
Right.
There's then a big group of cases which are the minor cases, for example, theft, shoplifting, public order, some of the minor public order offences. They are all kept in the Magistrates' Court. And then there's a group in between, which can either stay in the Magistrates or go up to the Crown. And then it's really up to the defendant, the magistrates and the Crown Prosecution Service to decide. But at the end of the day, it's up to the defendant. They can choose whether it's going to be the Crown Court or the Magistrates' Court.
Right.
Then, down at the Magistrates' Court, the simple, what I would describe as basic trials take place. If convicted, you get sentenced.
Right.
If acquitted, you're obviously let off. You'll be found not guilty. But it's the magistrates that decide. Now, a magistrate could either be a trained district judge, or we call them stipendiary magistrates, or it can be three, what we describe as lay people, normal people off the street with no legal qualifications whatsoever. They do that job for free. If you're unhappy with the verdict, in other words, if you're unhappy that you've been found guilty, you can appeal to the Crown Court.
Right.
As I've explained, the more serious cases that go to the Crown Court, that's where their trials take place. But before the trials take place, we nowadays have what's called, we call it a PTPH, and it's a pre-trial preparation hearing. And that's really where the judge deals with the case and makes a number of orders so that the trial will be ready when it's listed for trial. We try, if at all possible, to fast-track trials that involve juveniles, children.
Right.
The idea is any case that involves a child has to be heard within 10 weeks from charge. At the Crown Court, it's not the judge that decides whether somebody is guilty or not. We have a jury. I don't think you have a jury here,
No, we
do you?
don't have that system here.
We have a jury, which are just 12 people that are randomly selected. Again, they may or may not have legal qualifications. Anybody, well, almost anybody, can sit on the jury. And they listen to the evidence and then will decide if somebody's guilty or not. Obviously, if they're found guilty, you then proceed to sentence.
Right.
If you're unhappy with that, we have the Court of Appeal. Now, I had an opportunity to go and look at your Supreme Court this week when
Right.
I've been here, and I think the Court of Appeal are quite similar.
High Court Division.
I think it is. So in the Court of Appeal, that's where you can appeal against your conviction and or sentence. But I don't know whether this happens in Bangladesh, but in England, if you appeal against advice of your advocate, against advice of your lawyer, you can be penalised. And the Court of Appeal, if they disagree with your appeal, can force you to serve longer in prison. It's called time served. We then obviously have the Supreme Court, and then we have some European courts. But at the moment, as you may have heard, the UK has decided to leave the European Union.
Right.
So we're not too sure exactly what's going to happen there.
Well, that surely will have an impact, right? তো আমি যদি ব্যারিস্টার সাজিদ বিন এমডি তানজিদ কবিরকে বলছিলাম যে আপনি যদি বাংলাদেশের প্রেক্ষাপটটা একটু ওর সাথে আমাদের দর্শকদের একটু এক্সপ্লেন করতেন।
জি, উনি যেই ব্যাপারগুলো বললেন, আমাদের বাংলাদেশের কোর্ট স্ট্রাকচার অনেকটাই ইংল্যান্ডের কোর্ট স্ট্রাকচারের সাথে সিমিলার। যেমন ম্যাজিস্ট্রেটস কোর্ট থেকেই শুরু, ম্যাজিস্ট্রেটদের দিয়ে শুরু হওয়ার পর উপরে গিয়ে আমরা সেশনস কোর্টে যাই, যেটা ওখানে ক্রাউন কোর্ট নামে পরিচিত, এবং তারপর ঠিকই ওদের কোর্ট অফ আপিল এবং যেটা এখন সুপ্রিম কোর্ট, আগে হাউস অফ লর্ডস ছিল, সেটা আমাদেরও এখানে সুপ্রিম কোর্টের দুটো ডিভিশন, হাইকোর্ট ডিভিশন আর অ্যাপেলেট ডিভিশন হিসেবে আছে।
রাইট।
আরেকটা যেটা ব্যাপার উনি বলেছেন যে জুরি ওখানে আছে, আমাদের এখানে নাই। ওদের ওখানে জুরি কিন্তু শুধুমাত্র কনভিকশনটা ডিসাইড করে, যেটা হচ্ছে যে গিলটি অর নট গিলটি, অপরাধী দোষী কি নির্দোষ, এটুকুই শুধু ডিসাইড করে। আর তারপরে যেটা সেন্টেন্সিং এর পার্ট, সেটা কিন্তু মানে সাজা কতটুকু হবে এটা কিন্তু জাজ ডিসাইড করে ওখানে। আমাদের এখানে জুরি যেহেতু নেই, জাজ একাই এই দুটো কাজই করছেন।
কোয়েশ্চন অফ ল ডিসাইড করছে, ফ্যাক্ট সবই
ডিসাইড করছে এবং সেন্টেন্সিংটাও উনি করছেন।
রাইট।
এরপরে আমি যে দুটো জিনিস হাইলাইট করতে চাচ্ছি ওনার থেকে বাংলাদেশের প্রেক্ষাপটে, একটা হচ্ছে যে ওখানে উনি বললেন যে পিপিটিএইচ, যেটা হচ্ছে যে একটা ট্রায়ালের প্রি ট্রায়াল হিয়ারিং হয়, যেটা অনেকটা কেস ম্যানেজমেন্ট হিয়ারিং এর মতো, যেটা কিনা একটা কেস কিভাবে শুরু থেকে শেষ পর্যন্ত যাবে সেটার একটা প্রিপারেশন নিয়ে তারপরে কেসটা শুরু করা, যেটা আমাদের দেশে কিন্তু ওরকমভাবে হয় না। আমাদের দেশে আমরা জানি যে শুধু আমাদের দেশে নাই, উপমহাদেশের অলমোস্ট সবগুলো দেশেই কেসের যেই একটা লেন্দি প্রসেস এবং সেটার জন্য যে অনেকগুলো কেস এখনো পেন্ডিং আছে, সেটার জন্য হয়তো এটা আমাদের জুডিশিয়ারি বা আমাদের সরকার এটা যদি একটু চিন্তাভাবনা করে যে এরকম কিছু যদি করা যায়, আরও এফেক্টিভলি যদি করা যায়, তাহলে হয়তো আমাদের কেসগুলো আরও স্পিডি ওয়েতে সেটা আগাবে এবং তারপরে হয়তো নিষ্পত্তি হবে। আরেকটা জিনিস আছে যেটা হচ্ছে ইংল্যান্ডে প্রায়োরিটি বেসড কিছু হিয়ারিং হয়, যেটা খুব দ্রুত করা হয়। আমাদের দেশেও আছে কিছু ক্ষেত্রে, যেমন দ্রুত বিচার ট্রাইব্যুনাল বা এই জাতীয়, কিন্তু ধরেন একজন চাইল্ডের যদি কোনো কেস হয়, তাহলে সেক্ষেত্রে যে একটা প্রেফারেন্স দেওয়া হয়, একটা প্রায়োরিটি দেওয়া হয়, সেই বিষয়টা আমাদের এখানে হয়তো এরকমভাবে হয় না। উনি বলেছেন আরেকটা ব্যাপার যে ওখানে যখন ম্যাজিস্ট্রেট কোর্ট থেকে ক্রাউন কোর্টে যাচ্ছে, তারপর কোর্ট অফ আপিলে যাচ্ছে, এই বিষয়টা হয়তো উনি বলবেন পরে। সেটা আরেকটা বিষয় আছে যে ওখানে অনেকটাই ডিজিটালাইজড হয়ে যাচ্ছে সব কিছু, ওখানে ইলেকট্রনিক বেসিসে সব কিছু যেটা হয় যে আপলোড করতে হয়, এখন আর পেপার বেসড হয় না, যেটা হয় যে আপনি এখনো আমরা কিন্তু কোর্টে ডকুমেন্টেই সব সাবমিট করছি, এবং ওখানে এখন সব লয়াররাও ইভেন কোর্টের ডকুমেন্টও আপলোড করছে অনলাইনে, ইন্টারনেটে, এবং এমনও হচ্ছে যে উইটনেসদের যেই সাক্ষী গ্রহণ করা বা আপনার জেরা করা, এ ধরনের সব প্রশ্ন সব কিছু অনেক সময় ভিডিও লিঙ্কে হয়, যেটা অনেক সময় হিয়ারিংও হয় স্কাইপ অথবা ফেসবুক ফোন কল বা ভিডিও কলের মাধ্যমে। তো এই পর্যন্ত ওরা চলে গেছে, এবং আমরাও হয়তো সামনে এগিয়ে যাব এই দিকে ধীরে ধীরে,
কারণ আমরা একটা ইনিশিয়েটিভ বোধহয় নিয়েছিলাম কজ লিস্টটাকে ডিজিটালাইজ করার
জি,
ব্যাপারে, এবং
জি।
সেটা আবার যদিও অনেকের সুবিধার্থে এটা আবার ফেরত আসতে হয়েছে নরমাল পথে,
জি।
বাট
তবে আমার মনে হয় শীঘ্রই আমরা সেই দিকগুলোতে আরো সামনে আগাতে পারবো এবং এই ব্যাপারগুলো আরো স্পিডি ওয়েতে রিলিফ পাওয়ার জন্য সবকিছুই ব্যবস্থা আমরা করতে পারবো।
অবশ্যই।
Could I also expand on that?
Yes, definitely.
And forgive me if I'm wrong, I think you were also describing the digital court system.
Absolutely.
Yes.
This is very, very new in England, and it's been rolled out on the Crown Court and the Magistrates Court.
Right.
And everything is digital. Everything is on the internet. You get access to your case, and all documents have to be uploaded. But another thing that we're really developing in the UK at the moment is what's called special measures.
Right.
They've been around for about 10 years, but they're really, really developing now. These are to help vulnerable witnesses give evidence. And in fact, by the end of this year, a new programme should be rolled out where children in particular, and children who have been alleged victims in sexual abuse cases, not only will be giving their evidence in chief via a video, so
Right.
the video is just played in court, but also there's a new section called Section 28,
Okay.
where you have to cross-examine on the video as well, and that's pre-recorded. So
Okay.
before the trial even takes place, the full evidence of the child will have been recorded on a videotape, and the judge monitors exactly what questions you can ask or not ask a child.
Right.
And you have to now, which is very new to all of the senior barristers, you have to write down all the questions you want to ask the child in cross-examination. And the judge can just turn around and say, no, you can't ask it in that way, or you can't ask that question at all. So things are changing. And I think the idea, well, I know, the idea behind it all is so that witnesses feel more comfortable in court and are more willing to come forward to give evidence.
Rather than keeping it to themselves.
Yes.
Right. Lady Hill was appointed as the president of the Supreme Court,
Yes.
UK, right? So what does that mean to you as practicing barrister and the promotion of diversity, if I look at the involvement of women in this profession?
The fact that she has been appointed, I think, is absolutely amazing. It is a step forward and a step in the right direction. It is with regret that there aren't enough women in any judicial positions in the United Kingdom. I think about 3 days ago, the survey on equality and diversity was produced. And as I've said, I'm saddened to say that only 28% of all judicial roles are held by women.
Right.
Why? There's all sorts of reasons, but we have to change, because whether it is the Supreme Court, the Circuit Bench, the High Court, or even the magistrates, all different tribunals need to reflect society. And in society, I think in England there are now more women than men, only just,
Right.
but the judges really need to reflect that. So it's a step forward. I am hopeful that things will change. The fact that there are an awful lot more female barristers gives us all hope that in the future there will be more female judges. But I think compared to here and compared to the rest of Europe, England are way, way down the list on their judiciary reflecting the true picture of society.
And so there's sort of a gender disparity there.
Oh, it's not just a gender disparity. There is also a cultural disparity, a religious disparity, and also a lot of the members of the judiciary have all been to a number of different schools. It is changing, and it's changing for the better, but it's just taking a long time. And I think this is a tremendous step in the right direction, and I'm over the moon.
রাইট, আপনি যদি বাংলাদেশের প্রেক্ষাপটটা একটু আমাদের দর্শকদের উদ্দেশ্যে বলতেন।
আমি শুধু একটা জিনিসই বলবো এই ক্ষেত্রে, উনি নিজেও বলছেন
জি।
যে হয়তো ইউকে আমাদের দেশ থেকে একটু হলেও এদিকে পিছিয়ে আছে।
জি।
আমাদের সুপ্রিম কোর্ট মানে হাইকোর্ট ডিভিশন এবং অ্যাপেলেট ডিভিশন মিলিয়ে আমাদের কিন্তু ফিমেল জাস্টিসের নাম্বারস একটু হলেও হাই আমি বলবো ইউকের থেকে। আমাদের আমার ইফ আই এম নট রং ইটস অ্যাবাউট 6 or 7 around 10 maximum তো সেক্ষেত্রে আমরা এটা হয়তো এগিয়ে যাচ্ছি।
অবশ্যই।
আর নিচের দিকে হয়তো অন্য জাজদের ব্যাপারে, লোয়ার কোর্টের জাজদের ব্যাপারে, ম্যাজিস্ট্রেটদের ব্যাপারে আমাদের ফিমেল রিপ্রেজেন্টেশনস অনেক বেশি। তো সেই হিসেবে তবে যেটা উনিও বললেন যে বেশি হলেও যথেষ্ট নয়, এবং সেটা কিন্তু আমাদেরকে অবশ্যই সামনে আরো ইনক্রিজ করার ব্যাপারে এটা অ্যাওয়ারনেস বা এনকারেজমেন্টের একটা পার্ট তো থাকেই, সেটা সামাজিকভাবে হোক এবং সেটা পারিবারিকভাবে হোক। কিন্তু তাছাড়াও আমাদের এখন যেহেতু আমাদের সুপ্রিম কোর্টে অনেকজন সম্মানিত বিচারক আছেন, মহিলা বিচারক আছেন, তো সেই হিসেবে আমার মনে হয় এটা অনেক বড় একটা এনকারেজমেন্ট হিসেবে আমাদের লয়ার যারা আছে এবং ল স্টুডেন্টস যারা আছে তাদের সবার জন্য একটা এনকারেজমেন্ট হিসেবে কাজ করে।
অবশ্যই। So from your experience, what do you think are the important principles that are guiding sentencing in the UK?
Well, that has changed quite dramatically over the 25 years that I've been practicing. I think it's the Criminal Justice Act of 2003, and forgive me if I'm wrong, but I think it's section 142. I could be wrong about that, but I think it's section 142. Now the principles are enshrined in statute, and they cover, and there's 5 of them, and let's see if I can remember them all.
Right.
There is punishment, the most obvious one. There is rehabilitation, and that's very important in England, and it's reflected in some of the sentences we can receive. There is what's called punishment, deterrence, rehabilitation, and forgive me, retribution, but there's also another
reparation.
One. Thank you.
Yes.
I've been practicing for 25 years. You would have thought I would remember all of those. But what a judge nowadays has to do, whether he's or she is a magistrate or a circuit judge, he has to look at all 5 principles. He then has to look at the maximum sentence that you can get for that offence.
I'll get back to your question. We just have a phone call at the minute.
Oh, of course.
Hello. Hello.
Assalamu alaikum.
Wa alaikum salam.
আপা এই যে উনি কি মহিলাদের জন্য বিদেশি উনি কি আমাদের আইন বিদেশি
আবার বলুন।
জি আপনাদের সাথে যে বিদেশি ম্যাডাম কথা বলতেছে উনি কি বাংলাদেশের আইনজীবী নাকি বিদেশি?
না, উনি হচ্ছেন যুক্তরাজ্যের আইনজীবী। বলুন।
ও আচ্ছা। জি ধন্যবাদ।
আচ্ছা, আমরা এটা অনুষ্ঠানের শুরুতে বলেছিলাম। জি, so going back to the question, yes, so you mean for sentencing, or the judge has to assess all 5 of these?
Yes, the judge has to look at all 5 principles.
Right.
They then have to look at the types of sentence that you can impose for an offence.
Right.
We also, and again this is quite recent, we have something called sentencing guidelines. Nowadays, virtually every offence doesn't just carry the maximum sentence. It also has sentencing guidelines which anybody can look up on the internet. And these are set by the Sentencing Guidelines Council in England after consultation with ministers, members of the bar, members of society. It's quite a detailed analysis, but what they do is literally provide a table which lists in a table form the type of sentence a judge should give for an offence. So, for example, section 20, which is just grievous bodily harm, has a maximum of 5 years. Now, a judge wouldn't automatically give 5 years imprisonment. He has to take into account all of those factors that I've highlighted. He would then have to look at the sentencing guidelines, and he would have to work out whereabouts in the sentencing guidelines this case fell, because some cases may be much more serious than others, even though it's the same charge. Right. The judge will then reflect all of that, but in particular concentrating on the sentencing guidelines. And there's certain brackets that the judge will decide a case falls into. But in addition, a judge has to also give credit for a guilty plea in a sentence.
Right.
For all sorts of reasons, but in the UK they are trying to encourage people to plead guilty at the earliest opportunity. For example, it means that the courts aren't clogged up with lots and lots of cases listed for trial. So you have to advise your clients that if you plead guilty at the earliest opportunity, And that's just when the case starts. You haven't even received all the evidence. All you get nowadays is a brief summary. You have to advise your client, and if he pleads guilty then, a third is knocked off his sentence. So if, for example, somebody was looking at 9 years imprisonment,
Right.
the maximum he could get, if he pleaded guilty, would be 6 years. And that would be the maximum he could get. And then, obviously, the judge would look at lots of different things and see if he could reduce it even more. So, but you only get the full third off if you plead guilty at the earliest opportunity.
Right.
If you plead guilty when the matter's listed for trial, you can get as little as 10% off, and sometimes you don't get any time off your sentence.
So in order to apply these principles, do they also look into the condition of the defendant,
Yes.
age factor?
Well, they
and,
look
overall
at
case?
both sides. We have something called a victim impact statement. So if we look at the prosecution side first, the prosecutor will explain to the judge all about the sentencing guidelines and where they think it falls, which category.
Right.
They then have this victim impact statement, which is a statement written by the victim explaining how this offence has affected their lives. Very, very recently, it may be only in the past 2 years, victims have been allowed to decide whether the judge just reads the statement to themselves, or whether parts are read out in court, or the most dramatic and the one that has the most impact is when a victim reads out their own witness statement in front of the defendants and in front of the judge. In particular, quite recently, I had one in a murder, and the deceased's brother, who witnessed the murder, wrote an absolutely just harrowing victim impact statement. And at the end, I think everybody, including every single member of the jury, were crying because it was so heartfelt. And I have absolutely no doubt, and I prosecute and defend, that the victim impact statements are making a huge impact upon the length or type of sentence a defendant receives. On the defence side, you are entitled to what we call mitigate, and what that means is that you can say what you'd like, all the good points in favour of the defendant. So, for example, if they've never been in trouble before, if they have a family, if they have a number of different problems. And also, the defence have what's called a pre-sentence report, and that's a report written by another authority who's spent some time with the defendant discussing why they've committed offences, but in this report they also suggest what type of sentence may be appropriate. And the judge does take that into account. He or she may not always follow what the pre-sentence report says, but they will take it into account.
Right.
You've also got to bear in mind in England that we have a variety of different sentences. Obviously, life is the most serious. We then have imprisonment of all different lengths. We then have what's called a suspended sentence, where somebody is threatened if they don't do certain things, they will then go to prison for a period of time. We also have something called probation, and that's really part of the rehabilitation aspect of the principles. Probation is where a defendant will get help, and that could last for anything up to 3 years. And they get help from a variety of different agencies, but in particular from the probation service. We also have something called unpaid work, and that's where they have to work for no money for the community. We then have things like a conditional discharge, and also obviously fines. But the most serious is obviously life imprisonment. You can't get more serious than that.
Right.
Another thing that I spoke to some students about in Dakar recently was something called the Sex Offenders Register.
Right.
And you know, part of the principles is protection as well. And the idea here is if anybody is convicted of certain sexual offences, there's a number of things that happen. Not only do they receive their sentence, but they also have to sign on what's called the Sex Offenders Register. And that means they have to go to the local police station, they hand in their passport, they have to show bank account details and tell the police where they live. There's certain restrictions attached to it. So if they move, they have to inform the police before they move. If, for example, they decide to go on holiday, they have to tell the police where they're going, where they're staying and how long they're going to be away. If, for example, they wanted to move somewhere that the police did not think was appropriate, the police wouldn't let them. So, for example, it may be obvious, but they wouldn't be allowed to move next door to a primary school.
Right.
So it's quite a good power, and it's automatic in many of the sex cases, whether somebody's sent to prison or not. We also have other ideas, one called Sexual Harm Prevention Order. And that's an extra order that can be imposed if the judge thinks that there's a risk to society, a risk to the public. And what that means is that the defendant is given a whole load of conditions. And some of them can include, for example, not being in the same room or same place as anybody under the age of 16. Or one that's frequently used is that you are not allowed to delete your internet history.
Right.
And I think for obvious reasons.
I'm sorry I have to interrupt, but Katherine, we were in a very interesting conversation with both of you, but we're pressed for time.
Of course, sorry.
So thank you once again for being here, both of you. It was indeed a pleasure once again.
Thank you.
প্রিয় দর্শক, আশা করি আমাদের আজকের এই আলোচনার মাধ্যমে এই ভিন্ন আঙ্গিকে যুক্তরাজ্যের আইনের বিষয়টা ব্যাপারে আপনারা কিছুটা হলেও আলোকিত হতে পেরেছেন। এরকম আরো অনেক বিষয় নিয়ে ফিরে আসবো আপনাদের সামনে। চোখ রাখুন এটিএন বাংলার পর্দায়, দেখতে থাকুন ল অ্যান্ড অর্ডার।